Top 10 International Anti-Corruption Development for January 2022. Designed for busy in-house counsel, compliance professionals, and anti-corruption lawyers, this newsletter summarizes some of the most important international anti-corruption developments from the past months with links to primary resources. This month we ask, what did the U.S. Department of Justice (DOJ) have to say about payments made to foreign officials under duress? What lesson can be learned from the latest installment of Transparency International Annual Corruption Perception Index? Which industry was added to the scope of China's years-long anti-corruption crackdown? The answers to this question and more are here in our January 2022 Top 10 list. DOJ releases rare FCPA opinion procedure release addresses payment made under duress. In its first FCPA opinion procedure release since August 2020, on January 21, 2022, DOJ stated that it didn't intend to take an enforcement action against a U.S.-based company for making a payment to a third-party intermediary to obtain the release of a captain, his crew, and his vessel from detention in Country A. According to the fact presented by the company, the vessel had been detained by Country A's Navy when the ship inadvertently anchored in the country's waters. Country A detained the crew and captain, taking the captain on shore and keeping him in jail despite his suffering from serious medical condition. The company's appeals for assistance from the U.S. government were unsuccessful. A third party purporting to act on behalf of Country A approached the company and demanded a cash payment of $175,000 to release the captain, crew, and vessel. The company was concerned that the payment was intended for a government official of Country A and sought an opinion as to whether DOJ would take enforcement action if it made the payment. According to DOJ, given the highly unusual and exigent circumstances, it provided a previously unpublished preliminary opinion within days of receiving the company's request. According to the more detailed opinion procedure release, DOJ concluded that the company would not be making the payment corruptly or to obtain or retain business, two elements of an FCPA anti-bribery violation under 15 U.S.C. DOJ determined that the primary reason for the payment was to avoid imminent and potentially serious harm to the captain and the crew, and citing United States versus Kozani and the FCPA Resource Guide noted that action taken under duress do not ordinarily constitute crime. DOJ also determined that the company has no ongoing or anticipated business in Country A and found itself in Country A's water as the result of an error, which triggered the payment demanded by the third-party intermediary. DOJ credited the transparent manner in which it sought assistance from the U.S. government and ultimately an opinion from DOJ. DOJ also took care to note that the situation at hand is readily distinguishable from other situations in which a company is threatened with severe economic or financial consequence in the absence of a payment. According to DOJ, payment under circumstances that companies may perceive as economically coercive, especially in countries in which they are in historical, pending, ongoing, anticipated, or sought-after business relationship with government actors may well give rise to liability under the FCPA. Thus, FCPA Opinion Procedure Release Number 22 provide important guide to companies and practitioners in distinguishing between payment under duress and bribe payment. Transparency International releases Annual Corruption Perception Index. On January 25, 2022, Transparency International (TI) published its Annual Corruption Perception Index (CPI) for 2021. The CPI, which ranked 180 countries and territories around the world by their perceived level of public sector corruption on a scale of 0, highly corrupt, to 100, very clean, provide one of the major data points used by compliant professionals, outside counsel, and enforcement officials in assessing the anti-corruption risk of doing business in particular countries. TI considers scores below 50 to be failing scores, while scores below 30 indicate severe systemic corruption. Similar to last year, this year's top marks go to Denmark, Finland, and New Zealand, which tied for first place with a score of 88. Also similar to last year, the countries perceived to be most corrupt are South Sudan, scoring 11, ranking 180. Syria and Somalia, both scoring 13 and ranking 178, and Venezuela scoring 14, ranking 177. The United States achieved the same score as in 2020, 67, but fell 2 places in the ranking, 27, tied with Chile. Discussed in our client alert examining CPI result in the Asia Pacific region, China scoring 45, ranking 66, and Vietnam scoring 39, ranking 87, both improved their scores, while Malaysia scoring 48, ranking 62, Thailand scoring 35, ranking 110, and Philippines scoring 33, ranking 117, all lost points in 2021. And India achieved the same score, scoring 40, ranking 85. The average score globally was 43, and two-thirds of countries fell below 50. Since 2012, 25 countries have significantly improved their scores, but 23 countries have seen their scores significantly decline. DOJ promises robust FCPA enforcement in 2022. On January 27, 2022, Nicholas McQuaid, the Principal Deputy Assistant of DOJ's Criminal Division, spoke virtually at an FCPA forum hosted by the American Conference Institute in Houston, promising the FCPA enforcement would remain robust. In response to statistics showing that the enforcement of the FCPA appeared to lag in 2021, McQuaid stated that he would not overread or really read much into the number of prosecutions in a given year, and said he would expect to see some significant resolution in the next year. McQuaid highlighted that new enforcement approaches might lead to different type of resolution. I would expect to see some resolution from places that are familiar to folk, and also some new ones that people haven't seen in the past.